Hi, I'm Talia Baroncelli, and you're watching theAnalysis-news. I'm very excited about our guest today, international lawyer Triestino Mariniello, who's been representing the Gaza victims at the ICC. And of course, he'll be speaking about the recent arrest warrants against Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant. If you enjoy this content and would like to support us, you can go to our website, theanalysis.news, hit the donate button at the top right corner of the screen, and make sure you're on our mailing list. That way we can send all of our new content straight to your inbox. You can like and subscribe to the show on our YouTube channel or on podcast streaming services such as Spotify or Apple. All right, let's get into it with Professor Mariniello. I'm very excited to be joined by Triestino Mariniello. He is a professor of law at Liverpool John Muir's University and is one of the legal representatives to Gaza victims at the ICC. So it's really great to have you here today, Triestino. Thank you.
Thank you very much, Tyler, for the invitation.
My pleasure. So I wanted to speak to you about the ICC arrest warrants, which were recently released against Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant. And then, of course, also against Mohammed al-Masri, also known as Dave, who some presume might be dead, but there's been no confirmation of that yet. So why don't we initially speak about the legal effects that this warrant has, and then we can get into how countries like Israel and Germany actually stalled the proceedings.
Well, starting from the legal effects, it has already been widely discussed these days. The most immediate legal effect is that all state parties to the International Criminal Court, currently 124 states, since the 1st of January 125, because Ukraine will also become officially a state party to the Rome Statute in January, have the legal obligation under the Rome Statute of the International Criminal Court to cooperate with the ICC. Duty of cooperation includes the legal obligation to implement arrest warrants. So what does this mean in practical words? It means that if Netanyahu and Gallant should visit one of these countries, domestic authorities of the state parties would have such obligation under the Rome Statute to arrest them and extradite them to The Hague. So just to make it clear, I said a few times legal obligation, because we have heard a lot these days, particularly from some Western states, this sort of idea of political discretion in relation to the arrest warrants. When we talk about state parties, so in other words, for instance, all EU member states have ratified the Rome Statute, there is no such political discretion. They have the legal obligation. So if they should visit one of these countries, they should arrest them, otherwise they will be in violation of the Rome Statute.
Right, and we also recently heard U.S. State Department spokesperson Matt Miller say that state parties to the Rome Statute can use their own discretion when it comes to whether they'll apply these arrest warrants or not, which is obviously incorrect, as you've just laid out. But another thing that the U.S. constantly brings up when it comes to undermining the jurisdiction of the ICC is the issue of complementarity. So they're saying that democratic countries can start their own independent investigations and that the ICC can only intervene and start its own investigation as a last resort. So once that particular democratic country has finished up its own investigation. Can you explain why that is actually not the case here?
Well, we heard a lot talking about, in a way or another one, about complementarity. Complementarity is the cornerstone of the Rome Statute of the International Criminal Court, which means that the court can intervene only in those cases in which states that have a primary jurisdiction are unwilling or unable to genuinely put in place investigations. So the court intervenes only when there is a failure because of lack of willingness or inability by the states. In particular, the court intervenes, according to the jurisprudence of the International Criminal Court, if domestic authorities are not investigating the same person for the same conduct, which is under the attention of the International Criminal Court. But let's start from this widely discussed rhetoric of Israeli judicial system, which will be willing and able to put in place genuine investigation. Actually, in general, that does not reflect the reality. the Israeli domestic justice system, as it has been widely documented by UN independent commissions of inquiry, is completely unwilling to investigate and prosecute Israeli military and political leaders for serious crimes committed against Palestinians. This is not just my speculation. This is, as I said, is widely documented, for instance, by several international, even Israeli human rights organizations, and in particular by the UN independent commissions of inquiry, which have widely reported how the Israeli justice system, when it comes to crimes against Palestinians, has the aim to protect, to shield Israeli officials from prosecutions and from justice. So their role is not really to provide any justice. In the specific case of Netanyahu and Gallant, so we have to keep into account, first of all, this context. So context of a domestic justice system which is willing and most likely even unable to prosecute because of the lack of impartiality and independence. We are talking of the military justice system in particular, which would have competence over these crimes. But then the ICC also says that domestic jurisdiction has to deal with both the same person, the same conduct. So the ICC in this case analyzes whether there are domestic proceedings ongoing against Netanyahu and Gallant for the same conducts that are investigated. So for instance, for starvation, for conducting intentional attacks against civilians, and there is no such a thing in Israel. There has never been. Even in the previous wars, where, for instance, intentional attacks against civilians were widely documented. I refer, for instance, to 2014 military operation Protective Age. An Israeli leader, political military leader, has never been investigated or prosecuted for any crimes against the Palestinian victims. So that's why complementarity does apply here, because of the lack of a willingness and most likely also of inability by the domestic authority to investigate and prosecute Netanyahu and Gallant.
All right, I just wanted to read a statement from the ICC website so people can look this up. It's from November 21st, and it's a statement of ICC Prosecutor Karim Khan. He said, and I quote, "With respect to Israeli Prime Minister Benjamin Netanyahu and former Israeli Minister of Defense Yoav Gallant, the judges of the International Criminal Court have found that there are reasonable grounds to believe that each has committed the war crime of using starvation as a method of warfare and crimes against humanity of murder, persecution, and other inhumane acts as a direct perpetrator, acting jointly with others. The chamber also found reasonable grounds to believe that they are each responsible for the war crime of intentionally directing attacks against civilians as a superior." So what you're saying essentially is that Israel's supposed independent judiciary is not actually investigating the crimes that Netanyahu and Gallant are being accused of here.
Well, they are not investigating at all, so there is inaction, and when there is inaction by domestic authorities, that's enough to trigger the intervention of the International Criminal Court. We don't need to assess inability or willingness, as I was mentioning before. But even if domestic jurisdiction were investigating any cases falling under any of these crimes you were just mentioning, that would be not enough. I mean, this investigation should concern Netanyahu and Gallant, not any other individual in Israel. So only when domestic authorities will put in place genuine domestic investigation, genuine means impartial and independent investigation, criminal proceedings against Netanyahu and Gallant for the same conduct, that will be enough. But and Israel will have the possibility before the International Criminal Court to challenge the admissibility. In other words, to say that they are generally putting in place investigation. But that's never been the case so far for any of the most serious crimes committed against Palestinians. We are talking about Gaza, but the same applies to the West Bank. Again, I mean, I was mentioning before the 2014 military operation in Gaza, Protective Age, and the commission of war crimes, at least by the Israeli authority in that context, has been widely documented also by independent commissions of inquiry by the UN. No individual has ever been prosecuted or at least investigated for the commission of these crimes. Only some soldiers have been convicted for the theft of a credit card in the Gaza Strip at the time. So that gives already the clear idea of this alleged independent and impartial system that is widely used abused by some states to prevent the court to intervene.
Well, speaking about using and abusing the court system, we could also speak about the Germans and Israelis. I mean, Germany has tried to stall the proceedings. Israel was also questioning the jurisdiction of the court. Can you speak a bit about what both of these countries were doing in trying to stall these proceedings and stall the investigation?
Well, it's just not these countries. I mean, we need to make some steps back here. And we go back to when the prosecutor announced on the 20th of May 2024 the request of arrest warrants against 3 Hamas leaders and 2 Israeli political leaders, so Netanyahu and Gallant. After a few weeks, the British authorities, they decided to intervene into the proceedings, and to a certain extent, they de facto they challenged the jurisdiction of the court. They say that the court does not have jurisdiction they wish to say, they asked for an authorization to the court to say this, that the court does not have jurisdiction on Israeli nationals because of the Oslo Accords, agreements between Palestine and Israel. In other words, they argue that because Palestine cannot exercise criminal jurisdiction over Israeli nationals, cannot delegate this jurisdiction to the International Criminal Court. Then what happened was that, surprisingly, the chamber allowed the UK authorities to intervene in these proceedings, and that was quite surprising. I'm talking as legal representative of victims here, because there was a clear interference into judicial proceedings by a state which, at least under the previous government, the Tory government, always opposed to the investigation in the Israeli-Palestinian setting. But when the new government, under Starmer, they withdrew such a request, the court still allowed a long list of states, and this includes also Germany, as you were mentioning, but also the US, for instance, which are not a state party to the Rome Statute, as we know, to intervene and to submit dei amici curiae, raising a lot of issues which were not only confined anymore to the jurisdiction under the Oslo agreements, but also on complementarity, also on the lack of evidence, which is really difficult to understand because the arrest warrants requests are secret, as well as the arrest warrants, so how they could know the evidence submitted by the prosecutor is impossible. Even the victims, which are part to the proceedings, do not have access to the evidence submitted by the prosecutor. So this was an attempt by states, but also by a number of organizations and individual experts to prevent the court to intervene. Most of the states use political arguments. Going back to Germany, Germany surprisingly raised this argument that the court cannot intervene when there is an armed conflict. If the court were going to accept German authorities' allegation here, it means that most of the situations before the ICC should just be shut down by tomorrow. Because most of them regards, of course, context in which these crimes have been committed. Then again, surprisingly, Israel decided for the first time ever also to intervene, which also is a de facto recognition of the court itself, of the legitimacy of the court. Israel had always decided to boycott the court, not to recognize any role, but at the same time was using some other organization, their political allies, and also some sort of what we called proxy to intervene before the court. But this time Israel intervened, and they challenged the jurisdiction of the court first of all, but this was rejected exactly on the same day in which the court issued the arrest warrant. So the court, the chamber rejected both the challenges submitted by the Israeli authorities. I mean, to be honest, all these submissions by states, at least states inviting the court not to intervene, because there is a long list of states which that have also submitted allegation asking the court to intervene, saying that the court has jurisdiction. But those ones opposing the investigation, they were just really raising political arguments or unfounded legal arguments. And so the suspect is that the tactic was to delay the issuance of arrest warrants. The same tactic by the Israeli authority, which at a certain point also, we can say to a certain extent, also challenged the impartiality and independence of one of the 3 judges, but this as well has been proven completely unfounded. And that's why the court could proceed with the issuance of arrest warrants.
So I wanted to ask you about the evidence on which this case is based. If I understood correctly, it begins on October 7th, the day that Hamas launched its attacks, and then continues with Israel's onslaught on the Palestinians and its genocidal war. But it ends on May 20th, I believe. Why is that?
Because that's the evidence. The court clearly chambers that these crimes have been committed at least until 20th of May, because this is the date that when the prosecutor submitted the arrest warrants request. So, of course, the prosecutor now is in the ideal position to submit further evidence showing the ongoing commission of these crimes, but also of other crimes which are not included. I mean, we can talk about that as well. The investigation and the request of arrest warrants, as well as the issuance of arrest warrants, has been welcomed also by Palestinian victims with huge enthusiasm. But this scope of the investigation, in our views, is still narrow because it does not include a long list of widely documented crimes against Palestinians, in particular in the Gaza Strip. We are discussing that, but we could go easily to the West Bank, including East Jerusalem. For instance, in the Gaza Strip, the forced displacement of almost 2 million of people in a context in which there is no safe place. This amounts to a crime against humanity and also to a war crime under the status of the International Criminal Court, and has been widely documented in these 13 months. So why it's not included in the investigation? It's quite surprising. The same applies to the crimes against the Palestinian detainees in the Gaza Strip. It's been also widely documented the use of torture and inhuman and degrading treatment against them. So we would expect that the investigation would extend also to that. But the investigation would extend also to the genocide. We can go back to that talking about the ICJ, but the conduct also that the chamber is discussing in its arrest warrants includes conduct that, if put in place, for instance starvation, can be a measure imposed to destroy in whole or in part Palestinians as a protected group, if there is the genocidal intent. We strongly believe, as discussed before the International Court of Justice, that there is this genocidal intent, so we would expect that the prosecutor would extend his investigation also to this crime.
I just want to back up a bit and speak about the court from 2009 and how victims of Israeli operations in the Gaza Strip and West Bank and East Jerusalem have been trying to litigate their case at the ICC and to try to recognize the jurisdiction of the court. This started in 2009 after the Israeli operation Cast Lead, but I don't think it was until 2014 and then officially in paper in 2015 that the ICC actually recognized Palestine as a state and thus would have jurisdiction over issues in that particular area. So could you speak about how there's been this delay on the part of the court initially saying that, Palestine doesn't fulfill the requirements of statehood?
So I think this is a great point because it gives us also the possibility to place the current investigation and the current arrest warrant within the bigger context. And as a lawyer, we cannot ignore in this case the context before the International Criminal Court. And really, it's poorly reported how the situation in Palestine, as you correctly say, the trial started in 2009, not on the 7th of October, also to deconstruct the rhetoric that everything started on 7th of October. So, why in 2009? Because in 2009 there had been another military operation in the Gaza Strip, which killed thousands of civilians, and that was Operation Cast Lead. So what happened at the time was that Palestine decided to accept the jurisdiction of the International Criminal Court, which is a possibility that every non-state party has, accepting the jurisdiction. So even if you are not a state party, you enable the court to intervene by accepting this jurisdiction. It took the then prosecutor of the International Criminal Court, the Argentinian lawyer Luis Moreno Campo, 3 years to issue a sort of decision of no more than 2 pages, in which he actually said that he didn't know, more or less, I'm exaggerating, but that's the sense, whether Palestine was a state or not under the statute of the International Criminal Court. In these 3 years, the prosecutor discussed with experts, organizations, civil society organizations, with states about this issue. And he say, and surprisingly, very surprising, In contrast to what the Rome Statute said, he decided to delegate this issue to political bodies, which were the Assembly General of the United Nations and the Assembly of State Parties to the ICC, which are political bodies. The question was, why not raising this issue before the competent judicial authority, which under the Rome Statute is the pretrial chamber? And that was the decision in 2012, so 3 years after the acceptance of the jurisdiction. But then in November 2012, the Assembly General took a position on this with a big majority by recognizing Palestine statehood in that case as a non-member state to the Assembly General, as an observer state. And then again, everyone was expecting that then the prosecutor was going to open the investigation because there was an answer to his question, but he completely ignored the decision of the Assembly General. And then we go back to 2014. In July 2014, there was another military operation, the one we were mentioning before, Protective Age. Again, thousands of civilians killed by the Israeli authorities in Gaza. After that, Palestine accepted again the jurisdiction of the International Criminal Court, but took a faster step this time. For the first time, it also ratified the Statute of the International Criminal Court. The state of Palestine followed the correct procedure, and in 2015 was admitted by the Assembly of State Parties to ICC as a state party. Was also included in the Bureau of the Assembly of State Parties, which is the body that exercise supervisory control over the activities of the Assembly of State Parties.
Just explain who that is. Is it just is it like a chamber, several judges who decides?
It's the assembly of all the states that have ratified the Rome Statute. He was admitted in 2015 and was taking part to all the elections of the Assembly of State Parties. He was a donor state, put all rights and duties of the state parties. Then, at the end of 2019, the former prosecutor of the ICC, Fatu Bensouda, the second prosecutor, she announced that the conclusion of her preliminary investigation when she said we have enough evidence concerning war crimes by the Israeli Authority and Palestinian armed groups in 2014 in the Protective Age military operation, in 2018 in relation to the Great March of Return by the Palestinian authorities, and in relation to the settlements as a war crime in the West Bank. But the prosecutor decided, the former prosecutor, not to start an official investigation, but to raise again the issue of Palestine statehood before the chamber, correctly this time before the chamber. To be honest, there was no need because it had already been clarified, but she decided to raise this issue before the chamber and also to ask the chamber the following questions. Is Palestine a state under the Rome Statute? First. Second, what do we mean for Palestinian territory? And in February 2021, the chamber issued a decision. This decision said Palestine is a state under the Rome Statute, and Palestinian territory means West Bank, including East Jerusalem and the Gaza Strip. So that's where we can exercise our jurisdiction. In light of this decision, it was surprising that then the issue on the jurisdiction was reopened a few months ago, what I was mentioning before.
Yeah, and I'm also wondering because there have been many reports illustrating how the Israelis have actually spied on former prosecutors and spied on Bensouda. So I'm just wondering if that perhaps intimidated former ICC prosecutor Bensouda to open the investigation any quicker, because as you said, she then, as opposed to opening the investigation, threw the question of jurisdiction back to the actual judges of the ICC. And John Bolton, for example, who was part of the Trump administration at the time, he was threatening to sanction the ICC. I believe that was in relation to the case of Afghanistan because Bensouda wanted to open up an investigation into U.S. conduct in Afghanistan. But do you speak a bit about the effects of that intimidation?
Well, on the last point, the Trump administration issued an executive order, which is an emergency legislation in the US generally that the US uses against international drug traffickers or against human rights abusers, serious human rights abusers. And it was for the first time it was used against an official of an international organization, the prosecutor and her staff. establishing economic sanctions and also reducing freedom of movement in the US, of course. Of course, we don't know the impact of these threats of the sanctions on the work of the office of the prosecutor. We know that the former prosecutor was extremely brave to conclude the preliminary examination, unprecedented decision at the time. I mean, we have seen what the former prosecutor Ocampo did, most likely as well under the US pressure, as it has been reported by some Palestinian human rights defenders who were attending a meeting with him. But it's extremely important in order to shed light on potential effects of such threats that there is an independent investigation. I think there should be an independent investigation, in this case asked, requested or by the Assembly of State Parties or by the Presidency of the International Criminal Court, because this will be beneficial to the court itself. I mean, shedding light on what happened in those years after The Guardian and the magazine Plus 972 have widely reported these threats, which included the former Mossad director, threats against Bensouda and her husband. That will be really crucial because it's true that the preliminary investigation was closed, but still the Palestine investigation situation was treated with exceptionalism compared to other situations. This referral to the pretrial chamber, which delayed the investigation. But for instance, something happened also those years. For instance, under Bensouda, when Bensouda was prosecutor at the ICC, the so-called flotilla case was closed without an investigation. The flotilla case, many will remember this, was an attack by the IDF, by the Israeli Defense Forces, against the Freedom Flotilla that was trying to bring humanitarian aid to the Gaza Strip under blockade. This is before the 7th of October, where Turkish activists were killed by the Israeli Defense Forces. Very surprisingly, the office of the prosecutor with Bensouda said, "We have enough evidence to conclude that the IDF in this case has committed war crimes, but these war crimes are not serious enough to warrant the intervention of the International Criminal Court." The problem is that the prosecutor used this concept of seriousness, of gravity, which is very ambiguous. But at the same time, the office of the prosecutor had opened investigations against other individuals in which there was a low number of victims. So comparing this with other cases, this became even more surprising, and so that many experts, including myself, got to the conclusion that this was a political, not a legal decision.
That was part one of my discussion with Triestino Mariniello. In part two, we get into the ways in which the US undermines international legal norms while saying that it still supports the so-called rules-based international order. See you next time.